Good morning. Today's Tuesday, June 2nd, 2020, and I was going to put up a quick video, a relatively quick video about Chapter 2. I actually might break it down into two parts because there's a lot of material there that I have a hard time summarizing in a very brief fashion. But let's get right into it. It's really about the court system and the jurisdiction of the courts. Might as well start with the concept of what jurisdiction is. And you probably already have an intuitive sense if you don't have an outright understanding of it. It's the power to adjudicate, the power to make a decision in a certain sphere of influence, if you will. We've probably seen it in all movies and TV shows where the FBI comes in or the local police department's involved and they say, you're out of your jurisdiction. This isn't your jurisdiction. And that's true of the court system. That's how it relates to that kind of question as well. Meaning each court has a certain degree of power, and not every court can hear every kind of case. So if you're going to be a plaintiff in a case, you're going to sue somebody because of some business transaction that was flawed and you believe you've been wronged and you're going to seek damages or injunction or something like that. You need to know which court you're eligible to bring your case to. But just as importantly, if you're being sued, you want to make sure you're in the right forum, that that court is the appropriate court for you to be dragged into, for lack of a better way of saying it. So jurisdiction in a nutshell, and I think I have a couple test questions on jurisdiction because it's an important concept. I know a lot of students don't like this stuff. They want to get into the contract issues. But you have to know the backdrop of how cases actually get resolved. And it's a good little civics lesson. Anyway, everyone should know a little bit about jurisdiction. Let's start off with the federal system, because it's actually a narrower system of jurisdictional power. We have at the highest level the Supreme Court of the United States. Supreme Court of the United States, for the most part, is a court of appellate jurisdiction, meaning they only hear appeals. But appeals of what? Federal questions that came out of the federal court, or federal questions that were actually dealt with in the state court. That confuses a lot of people. But if I have a First Amendment issue or a Fourth Amendment issue, that's the Fourth or the First Amendment from the United States Constitution. It actually can be dealt with initially in the state court system. If I appeal, I might eventually, you don't start off in the Supreme Court usually in an appeal, I might go to the Circuit Court of Appeals, then up to the United States Supreme Court. So the Supreme Court, in most cases, has appellate jurisdiction. They'll hear an appeal on a question of law, that somehow the law was interpreted wrong or the application of the law was done in some incorrect way. Does the Supreme Court of the United States have original jurisdiction of some cases? Yeah, they're very narrow, involving ambassadors sometimes when there's a lawsuit between one state and another. Other impeachment of the president, the trial of it will actually be governed in a way, although it's in the Senate, the Supreme Court will have some role, that the Chief Justice plays a role. So it's an appeal. And I always kind of laugh. Sometimes I'll get a client come to my office, I want to take this case all the way to the Supreme Court. I said, well, that means you want to lose at trial, because we don't want to go to an appellate court at the outset, because that means we've lost, and we have to find a legal error, not a factual determination being incorrect. I can't believe the jury thought I did it. I can't believe the jury thought I stole the money. That's not the appellate question. The appellate question has to be about a legal standard being misapplied or misinterpreted and creating an unfair outcome because of a legal error. Legal errors are what get appeals. Otherwise, everyone would appeal every single case in hopes of somehow overturning the verdict against them. It has to be a legal error. And that's why we want really good judges, because they're gatekeepers to make sure the process is fair and the law is applied appropriately. So appeals tend to be very narrow. So the federal level, highest court, the Supreme Court of the United States. We know there are 9 members through historical application and sort of custom, but nowhere in the Constitution does it say there'd be 9 members of the Supreme Court. We lived with that situation for centuries now, but there were times where there were 13 members previously, and there's one president, Franklin Delano Roosevelt, that actually thought about packing the court because the Supreme Court was basically shooting down some of the legislation during his era as unconstitutional. So we got the Supreme Court in the state of the federal level, very narrow jurisdictional issue. Not that it's not important, because when they interpret the Constitution or federal statute, we tend to live with that interpretation without amendment. The next tier down is called the Circuit Court of Appeals. I believe there are 13 Circuit Court of Appeals. They're basically regional in our country. We live in the First Circuit up here in New England. And this makes it very complicated, because you can have different circuits making different rulings on very similar legal questions, leaving the nation sort of as a hodgepodge of legal rulings. Usually when that happens, it will go to the Supreme Court and they'll resolve the issue for national application on a federal law question. And then we have the trial courts, which are the most important, I think, especially for purposes of this class. Trial courts are where facts are presented, law is applied, and a verdict is rendered. That's where the action is, in my opinion. Very rarely when we watch movies and TVs about court or law is it about the appellate court. It's usually about the trial court where witnesses testify and evidence is presented and conclusions are made. In the federal level, there are several courts, several trial courts or courts of original jurisdiction where a case can start. The main one, the one you'll deal with contract law, is called the Federal District Court. Every state has at least one. Massachusetts has 3. We have one in Springfield. That's just simply where they sit. One in Springfield, one in Worcester, and one in Boston. What's interesting, a lot of people think the more serious the case, the more likely it's a federal case. It's not necessarily true. Federal cases are actually very narrow. In the big picture of things, most legal disputes go to state courts, especially true of criminal law. 95% of all criminal law is state jurisdiction. So federal jurisdiction are things like involving 2 or more states or a federal statute. A federal statute or federal principle has to be in play, or you can't go to the federal court. So if someone says, geez, I want to sue and I'd really like to go to federal court, I think they're more professional there. I don't know what their rationale might be. I have to say, well, wait a minute. I have to have a federal question here. Is there some federal statute that you think has been violated? Or is there a constitution principle involved from the federal constitution? Or is there a federal regulation that's been allegedly violated? Then we might be able to go to federal court. Pretty narrow. There is a second tier, and this is going to be on the test. So pay attention if you're zoning out. It's called diversity jurisdiction. This is a second method by which your case may be eligible to go to federal court. This is where the plaintiff, the one suing, lives in one state or domiciled. Don't say live because people can have multiple residences, but they're domiciled, a legal domiciliary. And I'm not going to get too deep into it. This is not a litigation class. But their legal domiciliary is in one state. The defendant, the one being sued, has a legal domiciliary in another state. And you need both of these elements. That's the first element. It's called diversity of citizenship. 2 different states, and then the claim has to be on its face, on what's called a prima facie, meaning it's legitimately argued that the claim is worth more than $75,000. They don't want little minor cases coming to federal court simply because the plaintiff is residing in one state and the defendant resides in another. That would be absurd. So we have 2 different avenues in which we can bring our case to federal court or be sued in federal court. That is, you have a federal question, comes up under some federal statute, rule or regulation of the federal constitution, or diversity jurisdiction. You have a plaintiff that lives in Massachusetts, defendant lives in Maine, and the case arguably on its face, based upon a preliminary showing, might be worth over $75,000. And that can be debated, and there can be many hearings just on that question to see if jurisdiction is appropriate. Most diversity jurisdiction cases also can be tried in the state court. And this is a test question, I believe, on my drafting of the first quiz. It's called concurrent jurisdiction. That means you have a choice. The plaintiff can say, well, I've got this ability to go to federal court, but can I also maybe opt out and go to the state court? And oftentimes you can. Oftentimes it will be called concurrent jurisdiction. A case can be heard in 2 or more forums. And that's called forum shopping. Supposedly, I had a judge mentor of mine when I was first practicing. He said that's the most important thing you can do as an attorney is forum shop. Make sure you're in the right forum that gives your client the best advantage. And the courts are aware that we do those things. So the jurisdiction of court, power to hear a claim. We know the federal court is going to be courts of limited jurisdiction. You're not going to hear a ton of cases there in the big picture, but there are some. Bankruptcy law is almost all in the federal system. Copyright, patent, those things are federal questions. Those are all enumerated or articulated in the federal statute. So you might get there. And business law is certainly related to copyright and patent and things like that. So you might get there, and diversity jurisdiction will come up quite a bit. Doesn't mean you have to go there necessarily. You might be able to resolve those same questions in the state court. We have a similar system in the state sort of framework for the justice system. We have what's called the SJC. That's the initials for the Supreme Judicial Court. That's our highest court in Massachusetts. And again, just like on the federal level, the Supreme Judicial Court hears appeals mostly. Very few cases start there. The great bulk of them are going to be appellate review, meaning somebody took a case in a trial court and they felt like the law was misinterpreted or an unfair procedure was done, and the client got an unfair outcome as a result. And so they're appealing it. Very narrow. Questions of law, not a fact. If the jury believes you did the act, that is not appealable. But the fact that the judge let in a psychic to come in and said, based upon their card readings, the defendant must have breached the contract or must have done the crime, that's really an evidentiary flaw, or arguably. I think that one's a slam dunk, right? You can take that to the appellate court and maybe ultimately up to the Supreme Judicial Court. On the federal level and the state level, you don't always have a right to file or at least be heard before the Supreme Court of the state or the Supreme Court of the United States. It's what we call election. On the federal level, 9 members of the Supreme Court exist. 4, it's called the rule of 4. 4 have to say, we think this is of national significance. We think it's important to resolve this issue for national understanding. So 4 of the justices have to think it's important to hear. That doesn't mean they agree with your side or your principle. They just simply want to hear it. The same is true in the state court. You always have a right to appeal, but it's not necessarily to the highest court in your jurisdiction. So in Mass, just like on the federal system, we have an intermediate court of appeals. It's not called the Circuit Court of Appeals. It's just one. It's called the Massachusetts Court of Appeals. It's the intermediate court. And that's where you usually go first after you think you've been aggrieved or injured by a poor legal interpretation or application of law in the trial court. And again, going back to the trial court, what's the trial court? Well, it's the district court, the Superior Court, the Housing Court, the Probate and Family Court, the Juvenile Court, the Land Court. I think I named them all. For purposes of contract law, you're going to be concerned with the District Court and the Superior Court. They have very similar jurisdictional avenues, if you will, but in a nutshell, district court cases are presumptively on the civil realm worth less than $25,000. Presumptively, that presumption can be overcome, and a district court can grant more money. But on its face, it should be less than worth $25,000. Superior Court, over $25,000 in a contractual dispute, civil dispute. So that's the civil sort of answer to which of the 2 state courts you'd go into Massachusetts. You might have a housing court problem that specializes in things like landlord-tenant and things like that, probate and family, divorce and family law issues, juvenile court, juvenile issues. Land court is a very obscure court because many of those same questions can be resolved in the Superior Court. Again, concurrent jurisdiction, which court gives me the best advantage. I'd probably pick between the 2. I know this stuff is probably boring the hell out of you, but you need to be able to know, am I going to be in state court? Am I going to be in federal court? And you don't always need to know the answer. I just want you to have that sense that that question has to be answered. Maybe some research needs to take place. Which court can I go to, or which court can I be dragged into? And I don't always know the question. I have people come to my office and I say, Jesus, should I bring this to federal court? Can I bring it to federal court? Is this a state court question? And which state court should I go to? I don't have it. I've been practicing for 27 years now. I don't have it memorized in my head by any means. But you do need to know about the power of a court to hear a case. And the book does a nice job. I know some of you probably don't still have the book to this date, but they have some nice charts on there in the federal system. And it actually, in some respects, mirrors the state court system. And Massachusetts, I think, is often mimicked by the federal system in that the Massachusetts court system was developed prior to the federal constitution being created. And you'll see that there is a lot of similarities. And it's not us mocking or mimicking the federal system. It's probably the other way around. The book does get into some of the roles of the different players. You should know the term original jurisdiction or the court of record. That's where the case starts. And now I'm going to try to buzz through real quick the trial process. So there is a couple notes in here who the different players are in a court system. Who are the lawyers? How do you become a lawyer? How do you become a judge? Some of you are interested in that. I think some of you are probably legal studies majors. But even if you're just a business major, just taking a class because it fills a void or it's a general elective, everyone should know, how you become a judge in Massachusetts. Massachusetts, you're nominated by the governor, and you have to pass not a review by the legislature like in other states or in the federal system. Actually reviewed by a very obscure group called the Governor's Council. And those 8 members, there's regional offices throughout the state. We elect the Governor's Council membership. They will determine whether or not the governor's appointment to the judiciary is appropriate. In Massachusetts, you don't serve for life. You serve until you're 70. But other than that, it's basically a lifetime appointment during that interim years. So you get appointed at 50, you can serve 20 years, and you're kind of forced to retire at 70. Most judges, I don't know of any judge in Massachusetts that's not a lawyer prior to becoming a judge. Those of you that are interested in becoming a lawyer, Basically, you have to have a bachelor's degree. It doesn't have to be in pre-law. It can be in anything you find interesting or driven to. And as long as it helps you with critical thinking skills and reading comprehension and writing, it'll serve you well in law school. Then you do another 3 years at law school. And then you get your Juris Doctorate. And after that, you take the bar exam in your state. The first half of the bar exam is 8 hours. Everybody in the country takes that same half. It's called the multi-state. And then the next day you take another 8-hour exam, and that's all essay, usually based upon your state law jurisdiction, which often overlaps significantly with other states' legal principles anyways. And then you become a licensed lawyer. And maybe someday the governor may select you to become a judge in one of our court systems. That's in the book, and it might intrigue some of you that are legal studies major on how to do that. And some of you might catch the bug, maybe not from this online business law class, but you might say, oh, geez, I'm thinking about becoming a lawyer now. I really like this law stuff. You certainly can. I'm a community college graduate myself, and if I can do it, you can do it. So if you're interested, don't shy away. And I know I read a couple of your, I read them all actually, all your introduction. Many of you were worried that you're an older student or something like that. Well, I'm, I think, older than everybody else in the group, and I just recently went back to school and got another degree because your age, you're still going to be aging and you're still going to be getting older. There's nothing wrong with still going forward with your educational goals and dreams. So don't feel like there's any limitation there. That's my dog sitting at my feet right here, and she's having a bad dream if you hear her whimpering. I'm not torturing her in any way. I'm going to show you. So filing suit in a civil action. This is kind of important. So you found the court of the right jurisdiction. This one was Gardner District Court, for example. We'll go right off the campus of the Mountain View Community College. You have a claim that's worth less than $25,000. It's some kind of breach of contract. Somebody has wronged you in terms of the obligation that they had on their end. So usually file a document called a complaint. A lot of people think it has to be very fancy. It has to have a lot of legalese. Actually, it's just a plain, simple statement of the nature of your claim and what you want for a remedy. I want $10,000 or I want $5,000 because this person entered into a contract with me and they gave me damaged goods or they shorted me on what was expected under the contract, and that's how I've been harmed. Something straightforward like that. You file it in the court, you do a filing fee, and now just because you filed in court, the defendant, the person you want to sue, doesn't know that yet. So you have to have them served, and there's some technical rules. We're not going to get into it. I usually hire the Worcester County Sheriff's Department, if it's a Worcester County case, to do service of process. They have a civil branch, and they'll go out and bring it to the defendant, usually at their home. But if it's a business, they'll send it out to the registered agent to receive service for a corporation. If you take litigation with me or somebody else at the college, you'll get more specific about how to make sure the correct person is served. But it's about notice. It's about due process, about fundamental fairness. Imagine being sued and not knowing why you're being sued, the who, what, when, and where would allegedly happen against you. And now the ability to present a defense. So after you file a suit, you don't get a trial like a week later. You're doing small claims, get one pretty quick, 30 or 40 days. It's very rapid. But in a traditional lawsuit, you're going to get notice of the complaint against you. You usually respond to the complaint. You can deny everything generally. You can do a motion to dismiss because of lack of jurisdiction or because the claim is not something that's recognized in law. But usually what happens is you answer the complaint and say, hey, it's inaccurate. It's not true. I deny the allegations of the plaintiff. And then there's a period of time called discovery. During that discovery period, we can do depositions. That's where you sit down in front of a court stenographer. And there can be attorneys. It doesn't have to be. And you get questioned under oath. And that way people can know what to expect at trial, what that person's testimony is going to be like, and whether or not they seem truthful or whether or not their story is accurate. In that formal discovery process, depositions, that direct live oral examination of a witness under oath, or depositions, or I should say interrogatories, which are written questions sent to the other party that have to be answered under oath. And by doing that, you get to a sense of where's the other side's position? What do they believe really happened? And who, what, whens, and where about the circumstances following the case? Not only does it help you prepare for trial, but it also gleans light. It's like playing cards and say it's a 5-card, I can't remember all the different poker games. So say I have 5 cards and you have 5 cards, but 4 of them are up, meaning I see 4 of your cards face up and you see 4 of my cards face up. Because all these facts have been given and supplied to either side through discovery, depositions, interrogatories, and then the other one, the big one. There's many tools in discovery, but these are the main ones: depositions, interrogatories, and then it's called request for production of documents. If I have documents like a copy of the contract or photographs of the damages that were done to my property, you have to supply them to the other side when they request them. And that exchange of information helps the parties in many circumstances kind of see the light and say, I think I still have a good case, but it's not quite as rich in value as what I first thought. Or the other side might say, geez, I really did kind of screw up on this contract. I do owe them some money, and maybe settlement will occur. So the process of discovery is, we don't want trials by ambush. It's unlike movies and TV shows where there's a surprise witnesses come in and evidence produced that stuns everybody, and there's all these moans in the courtroom. We usually know what everyone's going to say and produce at trial ahead of time. We don't always know all the nuanced information that's going to come out of trial, but we know who's going to testify ahead of time, and we have the opportunity to speak with them through depositions or interrogatories prior to the trial. It gives us a fair amount of predictability, and that's why preparation is so important, especially those who want to be paralegals and attorneys. It's all about preparation, and that's why 90, I don't know what the figure is, I know it's well into the 90 percentile, that most civil cases get resolved prior to trial, because we kind of hash out what's really going to be proven at trial ahead of time. And then after the discovery period's over, we can do motions to dismiss and different motions to hone the issues, because cases don't always resolve at trial. They resolve prior to trial because of flaws in the case. But at trial, and this is the thing I'm going to try to burn through right now, the trial procedure is that the plaintiff goes first, and whether or not you have a jury or not is a civil case. Standard is you don't always have a right to a jury trial. In workers' comp, for example, there is no right to a jury trial. An administrative law judge will hear a case, and that surprises people. Oh, I thought with the Constitution we always have a right to a trial. That's in the criminal realm. The Sixth Amendment always gives you a right to a trial if you're charged with a crime. But in the civil realm, you have a right to a trial according to the Seventh Amendment if the claim or controversy was recognized that we call common law, meaning at the inception of our country where these cases tried before a jury and the claim is worth more than $20. That's the Seventh Amendment to the United States Constitution. Then you have a right to a jury trial. So, as a nutshell, most civil disputes related to business law, you're going to have a right to a jury trial. But does that mean you have to have a jury trial, or could you have a trial just in front of a judge? In the civil realm, both the plaintiff and defendant have to agree to waive the jury, because it's the defendant's right to have a jury trial, but it's also the plaintiff's right to have a jury trial in the civil session. So sometimes, usually it's often know the other attorney involved in a case, and you might know the other party, and you want to do things, civilly, meaning, with a certain degree of fairness. And you might see the other side goes, hey, we've got Judge Smith up there, man. She's fantastic. And the other side goes, yeah, she's really fair. And she's going to give us justice today. He goes, well, let's take away the formality of having a jury and panel, which is a hard process I'll get into in a second. And let's just put the matter in front of her, because we can cut right to the chase, and she's great on the law, and she's just going to want to know that, the real meat and potatoes of the facts, and we're going to get a good judgment out of her, both of us will. Let's waive the jury trial. So you can have what's called a bench trial, or just a judge trial. And we can do the same thing in the criminal realm. In the criminal realm, it's different, though. It's only the defendant that has the right to the jury trial in the criminal realm, and it's the defendant's decision whether to have a judge trial or a bench trial or a jury trial. And those factors go into the same thing as the civil one. Do I think I have a really good judge representing the defendant? And maybe the facts are troublesome, meaning that although my client's not guilty of the crime, their involvement in the facts make them look, sleazy or unlikable. And that creates a lot of prejudice, I think, in the mind of a jury. And I might want to go in front of the judge, who I think is extremely fair and rule of law oriented and not afraid to apply the law as it's meant to be applied, and won't take all those emotional factors into play. So let's assume it's a jury trial. I come in with the defendant. I'm the plaintiff. I'm representing the plaintiff. We come into court. Judge makes sure all the preliminary matters are out of the way. This surprises a lot of people. All the evidentiary rulings usually have been done at a pretrial conference, so we know what to expect at trial. There's usually not a lot of debate about whether some document's going to be able to be used at trial. Hopefully, there's always some controversy, but for the most part, we kind of know what to expect. It's almost like we practice for a play, and we're going to present it to an audience, and that's going to be the jury. What's the jury's role when they come in? Well, they come in 50 or 60, will come in the room, and we've got to do what's called voir dire, and it's a French term. I think it's VOIRDIRE, and voir dire is I think it translates to speak the truth. I don't know why we use that term for picking a jury trial, jurors, but we want them to be impartial. There's a lot of historical belief and cultural belief that we are entitled to a jury of our peers. That's not in the Constitution, and it's not in any statute that I know of. We're entitled to an impartial jury. I don't know what jury of my peers would be. A bunch of middle-aged guys that are eccentric, and I don't know what does it mean to be a peer. Do they all have to be the same religious background, ethnicity, and age, and personality? That's a tough question, and those things are still being hammered out in some of the debates we have about our justice system today. What does it mean to be tried by a fair and impartial juror? Does it have to be peers? If it has to be peers, I think it'd be almost impossible to impanel a jury. It just has to be impartial. So we ferret it out. Does anybody know me? Does anybody know the other side? Do they know the witnesses? Do they know anything about the claim or controversy? Have they read anything in the newspapers about it if it's a big deal? Formed any opinion? And we try to make sure we have very neutral jurors. Like I do a fair amount of OUI practice. If I'm representing a defendant in OUI, I make sure none of the jurors have lost family members to a drunk driver, or maybe I don't even want someone who they themselves have been charged with an OUI, because they might think like, well, I got punished. I'm not going to let them get off the hook. They should get punished too, because I was even less intoxicated than this individual. So people don't have a taint, if you will. Just going to hopefully hear the evidence objectively and make a fair conclusion of the facts. That's all the jury does, determine facts. They don't determine law. They're not to determine justice. They are presented evidence, and their role is to determine who to believe, what to believe, and determine what happened factually based upon a preponderance of the evidence in the civil case and based upon proof beyond a reasonable doubt in the criminal case. What's interesting about that is I still think the jury, how do you instruct them on the law and the facts, and you say all you are to determine is the facts. I, as the judge, if I were a judge, would say, I'm going to present you folks the law, and you have to apply the elements of the law to these facts. I think the reality is that jurors, whether it's a criminal case or a civil case, do what they think is fundamentally fair in terms of how the evidence was presented and how it struck them. I think they have a tough time. Oh, geez, this is a criminal case. It's proof beyond a reasonable doubt. We have to be really, really quite sure. And this is a civil case. We don't have to have that much proof. We just have to think it's a probability. And I don't know if we have that mental ability and emotional ability sitting as jurors to really ferret out those differences. And also not to try to come to what we think of as a natural law conclusion, just to be fundamentally fair in terms of everything we heard. And even though we're bound to follow the law, when the jurors are done, they hear all the evidence and they go in and deliberate. The reality is no one listens to them. There's no court officer in there. There's no judge in there. And many of them will make rulings based upon things outside the law and perhaps outside even the factual conclusions that were delivered to them. But that's a jury trial. They go and they deliberate. And if it's a civil case, they come back and they will find the defendant either liable or responsible, or not liable or not responsible, or in favor of the plaintiff. Criminal case, they come back with a verdict that's either guilty or not guilty. And again, in the criminal session, this is a repeat of Chapter 1, the jury has to be unanimous. In a civil forum, they simply have to have a majority conclusion in order to render what we call a verdict. Are those verdicts appealable? Yeah, I already said that. We can go to the appellate court in Massachusetts, the intermediate appellate court, maybe to the Supreme Judicial Court. But what are we alleging? That there was an error of law in the way in which the trial was conducted. Not that the jury came to the wrong conclusion. That's not appealable. That's why most cases don't get appealed. Big chunk does. Our justice system is packed with cases. So a lot of people think, well, how can you say that? There's all these cases that aren't appealed. But in terms of percentile, they're very few and far between, and many of them get thrown out because they don't have a valid error of law to allege. And that's the trial procedure in a nutshell. I know this chapter's been kind of long. I apologize. But appeals, again, we'll have a test question on that. Again, an error of law, and heaven forbid that happens. I tell my clients that all the time. If we lose today, can we appeal? He goes, well, of course we can appeal, but we have to say that the judge or something in the procedures or the way it was interpreted or the conduct of the trial was done in violation of law. And we don't want that. We want a fair trial. And that's why most cases do end at the trial. I do want to talk briefly about small claims. Hopefully some of you are thinking, geez, can I get something practical out of this course? We're getting really deep into jurisdiction. Yeah, here's the practical, discussion of the day. Small claims in Massachusetts right now are up to $7,000. That's pretty significant. You might be a small business. You might have a lot of accounts receivable, clients that haven't paid you for monies owed. Do you really want to hire an attorney? Do you really want to have a case? And by the way, most civil cases take years to get to trial. The discovery process, the scheduling of matters takes an awful long time. I'll tell you, the courts have also been closed in Massachusetts for trials since March 14th or 15th. I had a bunch of jury trials scheduled actually during the summer months when I'm off from the Mount. I do a lot of trial work. And the courts are closed. And so there's going to be even a backlog there. So 2-3 years to get a jury trial really takes a long time. We can go to small claims. This video is going to go long because I'm also going to talk about alternative dispute resolution in a second. But small claims, $7,000 your claim can be worth. Do you need an attorney? No, it's actually, the system was designed hopefully that you wouldn't go with an attorney. You literally fill out a one-page form. Some of you may have done this already. Maybe you should put up a discussion board if you ever had that experience. You fill out this one-page form. You say, I bought a a set of ladders from this person for $400, and it turns out they were all broken and damaged, and they said they were in good condition, but until they were dropped off at my house, I didn't see it, and I'm suing them for $400, and I want them to get the ladders removed from my property. Small claims is perfect. Why? You fill out that simple form. Is very inexpensive, and I can't remember the difference. Depends on the amount of your claim. I believe between $0 and $1,000, you pay so much for a filing fee. It's very low. It's under $100, and then there's a tiered amount that you have to pay to file a small claims. Very, very inexpensive. Very easy to do, and you literally hand print. You hand write out what the nature of your claim is in a very simple form. The court actually has the defendant served, usually through mail. They mail it out to the defendant, and usually get a hearing 30, 45 days out, and it's very quick. The danger of it is you don't have a judge hearing your case or a jury. There's no jury. It's just in front of a clerk magistrate. They are often very experienced attorneys and do a very good job, but they don't have to be. The governor can pick people who are not necessarily attorneys to hear the case, and they might not have a very good grasp on legal principles or the rule of law. It's a little bit dangerous. And the other danger for the plaintiff is I decide to file small claims because it's easy, it's quick, it's not so formal. You usually have the hearing in a little office. The danger of it is you don't have a right to appeal. If you lose as a plaintiff in the small claims, you're waiving your right to appeal. And that's because you want the ease, the convenience, and the efficiency of a small claims case. I usually still recommend it highly. I do it in my own practice when a client comes in. If I see that the claim is worth under $7,000, I usually advocate for it. The defendant, however, if the defendant loses at small claims, they do have a right to appeal to not the appellate court, but to the trial court to have a jury trial, believe it or not. Doesn't happen too often, but that can really come up the system over a very small matter. Really shouldn't go to a jury trial, but it slows things down. And if a defendant really doesn't believe they owe the money or the damages, and they certainly should have a right because they didn't select the small claims forum. It was the plaintiff that did. Now, just a quick discussion because I know it must be in this chapter. It's called alternative dispute resolution, and if it's not there, I wish it was. And maybe it's in a later chapter, but it's called ADR. I hate acronyms because I don't speak in acronyms, and I go to meetings all the time, both in my law practice, but also as a professor at the college. And I often don't know what people are talking about. I just nod my head and act like I understand what's going on. But ADR stands for Alternative Dispute Resolution. We have a claim, we can file it in court, but both of us might decide to go to mediation. Mediation is taking it to a neutral third party and kind of hashing it out and having discussions with that mediator. And the mediator's there to facilitate conversation, to facilitate resolution. And they often break down. Initially, we have our little discussion, and then people get angry and upset. And then a good mediator will have facilities where the plaintiff will sit in one room, the defendant will sit in another. And after that initial sort of hope that we could all sit in one room and talk about, then we'll talk separate, and the mediator will come back and forth between the rooms and say, coming to me, for example, say, Jim, the other side is saying, X, Y, Z, and how do you really address that in your claim? And I'll say, well, yeah, that is important. And that's why we're only asking this much money, because we established A, B, and C very strong, and that allows us to have recovery. And why we're not asking that much money is because they are right about that aspect. So let me go back and talk to them now. And they'll jump back to the room and they go back and forth. A good mediator has very good listening skills. They're supposed to be a neutral. They're not making judgment, and they're not making any kind of conclusion who's right or who's wrong. They're trying to facilitate resolution. I didn't believe in it for a long time, but I have gone to a couple of mediations that were very successful. So I could never be a mediator, because I think when I hear situations, it doesn't take me long before I think, well, this side really should win and that side should lose. And my personality flaw, I guess. But mediation is a nice tool. It doesn't require resolution. So we can go to mediation today and hash things out for 8 hours, and we can walk out of there and say, we don't have an agreement. It's something that's voluntary. You have to agree with. You might be required to go to mediation, but doesn't mean you're required to come to a resolution of your case. Now, the other big one is arbitration. Arbitration does result in a conclusion. We'll have a third person, usually a retired attorney, maybe a retired judge, I should say retired attorney, but an attorney that, because of many years of experience, have become very knowledgeable in a certain area of law, and they're considered to be very wise in that area. Oftentimes they are retired judges. Judges retire at 70 and they're still very sharp and capable, and they want to still play in a realm in the legal world but not represent clients. They become alternative dispute resolution arbitrators, and they hear the facts. It's kind of like a mini private trial, if you will. No jury. You present your case. The other side, you present your case. It's a lot less formal, a lot less intimidating. Quite frankly, very predictable. I shouldn't say very predictable. Much more predictable than jury. Juries can do really bizarre things. You think you know a lot about jurors, and unlike television, we know very little about who our jurors are. And the both sides usually pick who the arbitrator is going to be. We take a list. Here's my 7 choices for the arbitrator, and the other side will say, here's my 7 choices, and we'll see, oh, there's a couple names that actually overlap. We'll call that arbitrator. We'll hire them. We usually share in the cost of the arbitrator's fees, and we'll go to his or her office, and we'll have a little mini trial in their office, and they'll render judgment. That judgment's usually binding, meaning that, okay, geez, they thought, we lost, but the good news is we only lost 20,000. The other side was looking for 50,000. Do we have to pay? Can we appeal it? The appeal is very narrow. You really have to cite some very flawed process. Otherwise, the arbitrator's decision is fully enforceable. You can take it to the Superior Court and ask the judge to enforce it under contempt rules if the other side doesn't pay. But it's a nice tool. It's very quick. You get into an office very rapidly. It takes out a lot of the formality. And a lot of arbitrators, I have to admit, try to do the process in such a way to get to people to buy into how he or she is going to rule, because they want people to be reflective that they got a fair day in front of a hearing officer, and it was done fairly and appropriately. This has gone on very, very long, and I apologize, but there is information here about how to become all the different players in the court, and the procedures of record. The questions at the end of chapter will help you, and that's the homework assignment. Obviously, you have to do some of those. Some of you don't have the book yet. Don't panic. The first assignment's not out until June 14th, I believe. Don't be afraid to ask questions. Chapter 3 does get into some more meaty stuff related to business law, like torts, private wrongs that usually have property damage or personal injury. A lot of people like that stuff. I love this stuff, so I love it all. But some of you are probably saying, wake me up when it's over. But let's try to get through it. If you have any questions or concerns, please don't be afraid to ask. If I miss your emails, don't be afraid to send a second one. I get paid for this. Don't be afraid to contact me at any time. And otherwise, I'll have hopefully a review for Chapter 3 up probably in the next couple days. So see you soon. Thanks.